5 seconds to go. Start. Therein, the impugned judgment was set aside, and the matter was remanded to the High Court for fresh consideration after hearing the appellant. Stop. Para. In the second limb of submissions, learned counsel for the appellant has contended that the High Court ought to have given an opportunity of hearing to the appellant before issuing the impugned directions. Stop. The learned counsel would argue that the test as to whether a person is entitled to an opportunity of being heard in challenge to an order passed by a magistrate is not dependent on whether such person had a right to be heard by the magistrate in the first instance, the entitlement to hearing has to be assessed independently by considering the consequences of the proceedings in which a hearing is sought, and a hearing could be claimed where a substantial right of a person would be affected. Stop. The learned counsel has referred to the decision in Divine Retreat Center versus State of Kerala and others, 2008 3 SCC 542, wherein, while dealing with the issue whether the High Court could have passed a judicial order directing an investigation against the appellant therein without hearing it, this court held that no judicial order could be passed by any court without providing a reasonable opportunity of being heard to the person who was likely to be affected by such order, while distinguishing the decision in the case of Union of India and another versus W. N. Chadha, 1993, Supplementary 4, SCC 260, by observing that the dictum in the said judgment would not apply where a challenge was to a judicial order directing an inquiry or investigation against a person or institution. Stop. The learned counsel has also relied upon a three-judge bench decision of this court in, wherein it was observed that an accused or a person suspected to have committed a crime has a right to be heard in a criminal revision preferred before the High Court or Sessions Judge against an order of dismissal of a complaint under Section 203 CRPC, as an order passed by the Superior Court in revision, overturning the order of dismissal of the complaint would, in effect, restore the complaint and hence, cause prejudice to the accused. Stop. Para. It has been contended that in the absence of the appellant, the High Court had no occasion to take note of the fact that he had already been exonerated of all charges after detailed departmental proceedings and hence, the directions for further investigation were wholly unwarranted in this case. Stop. Para. Learned counsel for the appellant has also argued that the High Court could not have directed for further investigation or re-investigation in this the matter in view of the dictum of this court, wherein it was held that fresh de novo investigation ought to be directed sparingly and in exceptional circumstances, like where the investigation already conducted is tainted by mala fides. Stop.